If you were born outside the United States but became a citizen the right way, through years of patience, hard work, and following every single rule, this video is for you. Because what I am about to tell you could change how safe and how secure you feel about your citizenship forever. Millions of naturalized Americans believe that once you take the oath, once you raise your right hand and swear your allegiance to the United States, that citizenship can never be taken away from you. It is yours. It is permanent. It is the finish line after one of the longest and most difficult journeys a person can take. But in 2026, that belief, that deep and completely understandable sense of security, is being tested in ways that this country has genuinely never seen before. Right now, in March 2026, the U.S. government is quietly but aggressively reopening old citizenship files, some from 10 years ago, some from 15 years ago, some from 20 or more years ago, methodically searching through them for any possible reason to strip people of the citizenship they already earned, already celebrated, and have already built their entire American lives around. And here is the part that is keeping people up at night. Even people who did everything completely honestly, who never lied, never hid anything, never cut a single corner in the process, are asking themselves the exact same frightening question tonight. Could they come for me next? Stay with me until the very end of this video, because I am going to explain exactly what is happening, who is actually at real legal risk right now, who is genuinely protected by the law, what specific steps you can take right now to protect yourself and your family, and what all of these sweeping immigration policy changes really mean for the 26 million naturalized Americans living in this country today. Before we go any further, I want to say something directly to you. This channel exists for people like you. Immigrants, naturalized citizens, families who worked extraordinarily hard, who followed every rule, who waited years and sometimes decades, and who simply want clear, honest, accurate information without fear-mongering, without political games, and without the kind of confusing legal language that makes already stressful situations feel completely impossible to navigate. If you have ever felt confused, scared, overlooked, or misrepresented when it comes to immigration news, this space is yours. I break things down simply, honestly, and with genuine respect for your situation. Because your future matters, your rights matter, and you deserve to understand what is happening to you. I upload consistently on topics like denaturalization, citizenship rights, green card changes, travel bans, USCIS policy updates, and what all of these changes actually mean for real people living real lives, not for politicians or policy analysts. So if you want updates you can actually trust, explanations you can genuinely understand, and content made specifically for you and your community, please subscribe right now. New videos on this exact topic and the fast-moving changes ahead are being uploaded regularly. Subscribing makes sure you never miss something that could directly affect your life, your family, or your future in this country. You earned your place here. This channel is here for you. Subscribe, and let us stay informed together. So first, let us make sure we all understand something very basic but very important. What does it actually mean to be a naturalized citizen? A naturalized citizen is someone who was not born in the United States, but came here from another country and went through the full legal process to officially become an American citizen. And I want to be very clear about something. This process is not easy. It is not quick. It is not something anyone stumbles into accidentally. It takes many years of consistent, documented, legal presence in this country. You need to already have a green card before you even begin. You need to have lived in the United States legally for at least 5 continuous years. You need to pass an English language test demonstrating you can read, write, and speak the language. You need to pass a civics examination where officials ask you detailed questions about American history, the Constitution, and how the government works. You go through multiple thorough background checks. You have an in-person interview with a trained immigration officer who reviews your entire history. And at the very end of this long, demanding process, if everything is approved, you attend an official naturalization ceremony where you raise your right hand and solemnly swear an oath of allegiance to the United States of America. This is a profoundly meaningful moment. For most people who go through it, it is the proudest day of their entire lives. They have been patient for years. They have been honest at every step. They have followed every single rule. And finally, they are an American citizen. They believe, reasonably, justifiably, that now they are safe, that now this cannot be taken away from them. But in 2026, that feeling of permanent security is being deeply shaken, and we are going to explain exactly why, clearly and honestly, right now. Today, there are approximately 26 million naturalized citizens living in the United States. These are people from every corner of the world, from Mexico and India, from the Philippines and Vietnam, from China, Nigeria, Pakistan, El Salvador, Ethiopia, and dozens of other countries. These are doctors and nurses, engineers and scientists, teachers and coaches, business owners and farmers, soldiers and veterans, parents, grandparents, aunts, uncles, and neighbors. These are people who love this country deeply and who have contributed to it in countless visible and invisible ways every single day of their lives here. And yet, in the early months of 2026, the Trump administration made an announcement that sent a genuine wave of fear through all 26 million of these people. The administration announced that it is dramatically and aggressively expanding its effort to take citizenship away from foreign-born Americans. This process is called denaturalization, and the scale of what is being proposed and implemented right now is unlike anything America has witnessed in its modern history. Let us talk about what denaturalization actually means and how it has been used historically, because that context matters enormously for understanding why what is happening now is so alarming. Denaturalization is the legal process through which the U.S. government goes to federal court and attempts to take away someone's citizenship. This power has existed in American law for a very long time. Historically, it was reserved for the most extreme and serious cases imaginable. For example, someone discovered decades later to have been a Nazi war criminal who lied extensively about their entire identity during their application, or someone found to have deliberately concealed a serious violent felony conviction when they applied for citizenship. These were rare, serious, thoroughly documented cases. Between 1990 and 2017, on average, only about 11 denaturalization cases per year were opened across the entire United States. Even during Trump's first term in office, from 2017 to 2021, the administration filed a total of 102 denaturalization cases across all 4 years combined. That is roughly 25 cases per year, which was already considered an increase from the historical norm. Those numbers give you a very important sense of how rare and how serious this tool was always considered to be. But now, in 2026, the Trump administration has issued new guidance that has genuinely shocked immigration experts, practicing immigration attorneys, advocates, and legal scholars across the political spectrum. According to this new guidance, USCIS, the U.S. Citizenship and Immigration Services, the federal agency that handles all immigration and citizenship paperwork, has been directed to send between 100 and 200 denaturalization cases per month directly to the Department of Justice. Let that number sink in for a moment. 100 to 200 cases, every single month. That is potentially up to 2,400 cases per year. Compare that to the historical average of 11 cases per year throughout the 1990s and early 2000s. Compare it to the 102 total cases across Trump's entire first 4-year term. What we are looking at now is an increase of a scale that is genuinely without precedent in modern American immigration history. Now, you might reasonably be thinking, okay, but if they are targeting people who actually cheated or lied during the process, why should an honest, law-abiding, naturalized citizen be worried? That is a completely fair and important question, and we are going to answer it very carefully and very directly. The official public statement from USCIS says that they are specifically targeting individuals who obtained citizenship through fraud or deliberate misrepresentation. A USCIS spokesperson has publicly stated that the agency has a zero-tolerance policy toward fraud in the naturalization process. On paper and in principle, that sounds entirely reasonable. Nobody, not immigrants, not advocates, not anyone, wants people who deliberately lied their way into citizenship to keep that citizenship. That is a defensible position. But the serious problem, and this is precisely where immigration experts and attorneys are loudly raising alarms, is in the details of how this policy is actually being implemented on the ground. The single biggest and most consequential concern is the quota system itself. When a government agency is officially instructed to produce 100 to 200 specific cases every single month, the pressure to meet that number becomes enormous, and many experts argue, inevitably distorts the process. Think about it this way. If your supervisor tells you that your entire department must deliver a specific numerical output every month or face serious consequences, you're going to search harder and harder for cases to fill that quota. You're going to look at thinner evidence. You're going to pursue smaller issues. You're going to reconsider things that previously would never have been considered significant enough to warrant action. Immigration experts are warning loudly that when you establish a rigid quota system like this, the very real risk is that the government starts pursuing people over minor administrative issues, small clerical mistakes on forms filled out years ago, or technical errors that would never, under any previous administration or any previously accepted legal standard, have been considered serious enough grounds to attempt to strip someone of their American citizenship. Former USCIS official Sarah Pierce articulated this concern precisely when she told the New York Times that requiring monthly quotas 10 times higher than recent annual totals transforms a serious and carefully reserved legal tool into a blunt instrument and creates widespread, unnecessary fear for millions of naturalized Americans who did absolutely nothing wrong. Let us also look at what has been happening in practice, on the ground, across the country in these early months of 2026. USCIS has been actively reassigning specialized staff members and dispatching trained officers to field offices in states across the country, specifically to review old naturalization files that were approved years ago, sometimes many years ago, and that were considered closed, complete, and final. These are people whose citizenship applications were carefully reviewed and lawfully approved. They built their lives in America. They raised children here, they paid taxes faithfully, voted in every election, some served in the United States military, and now a government official somewhere may be sitting in an office with their application from 15 years ago, going through it line by line, looking for any possible angle to challenge everything they built. The Trump administration's push to dramatically expand denaturalization is also part of a much broader and far-reaching immigration crackdown that has been escalating steadily since the beginning of the second Trump term. The administration has been conducting large-scale ICE enforcement operations in cities and communities across the country. They have been purchasing and converting warehouse facilities to use as immigration detention centers. They have been revoking visas, including the visas of international students and of individuals who participated in public protests. They have been initiating legal proceedings to remove people who hold green cards. And in December 2025, the administration took the extraordinary step of canceling naturalization ceremonies for immigrants from 19 countries that had been officially labeled as high risk. These were people who had completed every single step of the process. Years of waiting, extensive background checks, approved applications, scheduled ceremonies, and some of them received phone calls on the actual morning of their ceremony telling them it was canceled. Try to imagine that moment. Years of work, your family dressed up and gathered to celebrate with you. And then the call comes. The Trump administration also made the naturalization civics examination itself significantly harder at the start of 2026. The new version of the civics exam now includes 20 oral questions, double the number required under the previous version, and applicants must now correctly answer 12 of those questions in order to pass. Geography questions have been removed, but applicants are now required to name all 3 branches of the American government and demonstrate a deeper knowledge of constitutional structure. These changes add a meaningful additional layer of difficulty for people trying to become citizens through the legal process, precisely the people following the rules exactly as they are supposed to. There have also been important changes to green card rules that directly affect those on the path to eventual citizenship. Historically, marrying a U.S. citizen placed immigrants on an accelerated path to obtaining a green card. USCIS has now announced it will apply dramatically increased scrutiny to all marriage-based green card applications. Showing that you are legally married is no longer sufficient. The government will now conduct detailed investigations into whether couples actually share a home, actually share finances, and actually share a genuine life together, not just a legal document. Additionally, a significant travel ban expansion took effect on January 1, 2026. When President Trump signed an executive order adding 7 new countries to the existing ban list: Burkina Faso, Mali, Niger, South Sudan, Syria, Laos, and Sierra Leone. Citizens of these countries are now fully blocked from entering the United States. And under a rule that took effect in late December 2025, U.S. Customs and Border Protection can now collect facial recognition biometric data from all non-citizens entering and leaving the country, including lawful permanent residents with green cards, at airports, land border crossings, and seaports. Now let us step back and answer the question that matters most. Can the government actually take your citizenship away? And if they try, what legal rights do you have? This is critical, and we want to be absolutely clear. Yes, the government has the legal authority to pursue denaturalization, but it is not easy, it is not fast, and it is not automatic. Here is precisely how the legal process works. The government must first open a formal legal case against a specific individual. This involves a federal attorney filing either a civil or criminal case in federal court. The case then goes before a federal judge, not just a government official or administrator, but an actual Article 3 judge in a real federal courtroom, with all the procedural protections that entails. The government bears the full burden of proof at every step. That means it is entirely the government's job to prove that you did something legally significant enough to justify stripping your citizenship. You are not required to prove your innocence. The legal standard for denaturalization has been set very high by the Supreme Court of the United States, which has ruled multiple times, clearly and emphatically, that citizenship is too precious, too fundamental to American democracy, and too deeply tied to human dignity for the government to take away easily. The court has ruled that the government must prove not only that a false statement was made on an application, but that the false statement was material, meaning it actually affected the eligibility determination. A minor clerical error, a small omission, something that did not genuinely change whether someone qualified. Courts have consistently and clearly said that is not enough to strip citizenship. So what does all of this mean for the average, honest, naturalized citizen who is worried tonight? For the vast majority of the 26 million naturalized Americans who went through the process truthfully, answered every question honestly, and did not deliberately conceal anything material, experts say the real legal risk of actually losing citizenship remains low. The court oversight requirements, the high evidentiary standards, and the enormous time and financial resources required to pursue each individual case all serve as meaningful and real barriers against any kind of mass denaturalization. Immigration attorney and fellow Aaron Reichlin-Melnick noted that each case must ultimately be proved in front of a federal judge, and the Department of Justice is already operating under extreme resource constraints, so the quota may function more as a political signal than a realistic enforcement ceiling. That said, the emotional and psychological impact on immigrant communities right now is very real and cannot be dismissed. Immigration lawyers across the country report their phones ringing constantly from naturalized citizens who became American 5, 10, 15, 20 years ago and are now lying awake at night wondering if someone somewhere is reviewing their file. Senior staff attorney Veronica Garcia at the Immigrant Legal Resource Center confirmed that the fear is real and it is widespread, and experts argue that creating exactly this climate of fear and uncertainty may itself be part of the goal. When naturalized citizens live in fear, they are less likely to speak up, less likely to vote, less likely to participate in public and civic life. So what should you actually do right now? First, take a breath. If you went through the process honestly and completely, you are in a strong legal position. The protections are real. Second, gather and secure your documents. Make safe copies of your naturalization certificate, passport, and all immigration paperwork. Third, if you have a specific concern about something on an old application, consult with an experienced immigration attorney promptly. Do not panic and do not assume the worst. Get professional guidance specific to your situation. Fourth, remember that receiving any notice or letter from USCIS is not the same as losing your citizenship. There is a full legal process with multiple steps, and you have rights at every single one of them. If you receive any communication from USCIS or the Department of Justice regarding your citizenship, contact an immigration lawyer immediately. Fifth, stay informed. Policies are changing rapidly. Follow trusted legal organizations like the American Immigration Council, the Immigrant Legal Resource Center, and reputable local legal aid organizations who are actively tracking these developments and fighting for people's rights every day. If you found this video helpful, please like it, share it with someone who needs to see it, and subscribe to this channel. We are going to keep bringing you clear, honest, easy-to-understand information on everything affecting immigrant communities in 2026 and beyond. Leave your questions in the comments below. We read every single one. Thank you so much for watching. Take care of yourselves and take care of each other. We will see you in the next video.